As of September, that's the sneak preview, the big news, he'll be moving to Madrid at the IE Law School, IE University, and he will be an assistant professor in law there. But his claim to fame is probably his book on cyber operations and international law, which was published by Cambridge University Press in 2020, and for which he won the European Society of International Law Book Prize last year, I believe, right? Last year?
Yeah, last year.
Yeah, last year. He regularly lectures at several universities and institutes, which we are not going to list, as I'm trying to Google his name. A very long page will come up. I think the best chairs are those that don't say too much and don't take time from the speakers. Francois is going to talk about IHL, the use of force, and cyber operations, but I understand from a practical perspective, meaning by applying or trying to apply the rules to concrete examples of cyber operations. I've learned today that there is a Chinese proverb that says that complicated questions might have simple answers. So, Francois, do you have simple answers for the complicated questions of cyber operations in international law? We'll find out, and the floor is yours.
Thank you very much, Marco. Good afternoon, everyone. Good evening. Thank you very much for joining us. Thank you very much for the invitation for this presentation, for this lecture here. So yeah, the idea with this lecture is to discuss the application of international law to cyber operation in relation to armed conflict or in relation to high intensity operation, using different examples, but also mainly raising some questions. So the idea is not to have a lecture or to go through all the examples and having the implication of the law, but more to raise some question on how these questions have been approached, what have been the main questions that have been asked when it comes to the application of either the use ad bellum or use in bello, but also all the questions that we can see where actually we try to use these regimes for situations where they are not applicable and which has consequences for IHL or for use ad bellum. And I think it's important also to raise these questions because it has been an important trend on the international law applicable to cyber operation. So the first question, all the time we are talking about our international apply for research on our international and cyber operations, this question whether international apply to cyber operation in cyberspace, and then how it's applied. So these two questions have led to the development of an important body of literature. The most well-known being the Italian manual, which have been published in 2013 for the first edition. And the first edition was actually focusing on this question of the use ad bellum and use in bello. There has been the second edition in 2017, which adopted a broader approach, including also a question relating to the law of state responsibility. And there is now a third edition in preparation. Professor Roschini has also published a book on cyber operation international law, focusing on the question of the use of force, and I have also published a book on this topic, as it was mentioned. So there has been this question has been animating the scholarship for some time now. It has also been the case for states. There has been a lot of discussion among states on this question: is international applicable to cyberspace, and how international apply in cyberspace? And what is interesting with this discussion, and for example, if we take the example of the discussion within the United Nations, is the fact that this question of use of force and the law of armed conflict have been quite central in this discussion, but also in the failure of this discussion to time. And so that's what I want to bring here for the discussion. So we had the first resolution on this question that was introduced at the UN General Assembly in 1999 by the Russian Federation. And since then, there has been discussion on how to discuss about peace and security in cyberspace within the UN. So the title they usually use is development in the field of information and telecommunication in the context of international security. That was a term used for a long time now. We are referring more in terms of cyber security. And there has been this creation of different groups of governmental experts, gathering experts from different states, 15 states to 25 states, depending on the groups. We had 6 subsequent groups, and the first one actually failed because some states refused to talk about the law of armed conflicts during these discussions. And the 5th one in 2017 failed again because of IHL, but also because of the law on countermeasures and self-defense. What is interesting with this 2 failure and with this discussion is actually it has been perceived, it has been portrayed in a lot of discussion as if states were questioning the applicability of this body of law and were actually against the applicability of this body of law. And the states in question, so for the last failure were China, Russia, and Cuba, for example. And we had subsequent declarations from the states, in particular Cuba and the Russian Federation, which stated that they opposed to the discussion on these 3 set of rules, because for them, that will give a justification for the militarization of cyberspace. And that has been an important trend in the discussion. So the 2 elements, the 2 remarks I wanted to make here on this is, first, we should not overinterpret this kind of failure on the way this question has been approached and why we had this failure in the UN processes. And also, it's not really a contestation of the law in the sense that these states have made subsequent declaration where they reaffirm the application of part of IHL or part of the law of self-defense. So it's a different approach. It's more a contestation which is linked to the functioning of these specific processes and the fact that they refuse to have this discussion in this process and to have the focus of the processes on the law of armed conflict, on the law of countermeasure, and they wanted to focus more on other questions. So I think it's an important element to take into account where to dissociate contestations that are linked to the content of the law or questions linked to the content of the law from questions that are more linked to the politics of international law and the way international is discussed and is used by state in the interstate declaration. So with this introduction and with this different element, I wanted to express how the law of armed conflict and use ad bellum has been quite central in this discussion on how international apply in cyberspace. We have seen it about the Tallinn Manual, which focused on this question at first. It has been one of the main topic of discussion on contestation within the UN processes. We have also today several states who have published views on how international apply in cyberspace and which have been also focusing for an important part on this question of the law of armed conflict and use ad bellum. So one may wonder why we have such a focus in the discussion on international law. And before answering that, I will very briefly restate what will be a user or what will be, according to the scholarship, a user force in cyberspace or the question of the application of the law of armed conflict. So regarding the user force in cyberspace, so the user force is prohibited by Article 2, Paragraph 4 of the UN Charter. That's, I think, a given for people here. And it's also part of customary international, but the debate has been, we don't have a definition of what is force, and we don't have the definition of what will be cyber force. And there have been several discussions among scholars, but also among states on what will be this definition, with approaches focusing on the vector, approaches focusing maybe on the target, and then on the consequences. And today, the main approach is to say we should analyze cyber operations with their consequences, the scale and effect, and from there we will analyze whether or not they cross the threshold of the user force. It is generally conceived or accepted, I would say, that a cyber operation producing effect similar to an operation in the real world, to a user force in the real world, will qualify as a user force, namely destruction of property, injuries of people, or death of people. So that's the general approach. And if you try to apply this threshold and this approach to what we have witnessed in terms of cyber operation over the past 2 decades, let's say, it's always difficult to say when we started to witness really cyber operations, but a very limited number of cyber operations have actually come close to this threshold are only ones believed or is generally considered to have this threshold, which is Stuxnet, which was a malware which allegedly has been designed by the American and the Israeli to produce physical damages on a nuclear plant in Iran. So that's generally believed to be the example of a use of force in cyberspace, and it's what you find in most of the literature. Most of the, like all the other cyber operations, there is debate sometimes on whether they come close to the threshold of the use of force, but it has never been, they are not perceived as such. And also, if you analyze them from the point of view of what was the objective this cyber operation had, their objective was not to produce physical damages or to produce injuries or deaths of people. So even if you take it from what they are made for, it's a different purpose. So what I wanted to, the last point I wanted to make here is no state has ever qualified a use of force in cyberspace. So that's something quite interesting if you put it in perspective with the first part of my introduction, where I expressed that it's an important focus of interstate discussion, but then we have only one example of a use of force in cyberspace. From there, also, what we will have is, sorry. So there is kind of a frustration also sometimes that is expressed on this question, which is the fact that, yes, cyber operation may not cause physical damages, but they may cause high non-physical damages. They may conduct to the destruction of a lot of data with indirect consequences. And this has translated into an evolution in the approach in the literature, but also in state approach, where an increasing number of scholars, but also states, are today expressing the possibility for a non-destructive cyber operation to amount to a use of force. So, for example, it was expressed by France in 2019, and again this year, in the position that was released on our international apply to cyber operation. And I am quoting now, however, France does not rule out the possibility that a cyber operation without physical effect may also be characterized as a use of force. For example, penetrating military system in order to compromise French defense capabilities, or financing or even training individuals to carry out cyber attack against France could also be deemed use of force. So that's interesting evolution. So we don't have yet the affirmation that a non-destructive cyber operation will be a use of force, but states express, and this has been expressed by other states as well, the possibility of such a situation. Regarding the characterization of an armed attack, and I will not detail here, but it's generally perceived to be the use of force of highest gravity. So here we have already almost no example. We have only one, so we'll have no example of an armed attack. It's sometimes discussed about Stuxnet. It has never been clearly identified as an armed attack. Also because no state has ever, again, identified an armed attack in cyberspace. I have now discussed a key prohibition of the use of villain, namely the prohibition of the use of force. And the objective here was to show that it's of limited application. What I want also to restate is what is the objective of use of villain, which is to identify a wrongdoing state and the victim state, and to create the possibility for the victim state to reestablish the situation as it was before, take action to compel the wrongdoing state to stop its action. I am now moving to the characterization of an armed conflict in cyberspace, and I will be very brief on that. So cyber operation may take place during an ongoing armed conflict. They may contribute to the internationalization of an armed conflict, or the creation or identification of a new armed conflict. There is some question regarding the threshold of harm or the threshold of intensity cyber operations should reach to qualify or to trigger a new armed conflict, but there is no specific difficulty besides that. It's more difficult if you want to identify a non-international armed conflict, as there will be also some criteria as of the organization of the armed group and as of the structure of the armed group, which will be more difficult. From these different elements, what I wanted to show is, on this point, what my conclusion was to say, also we have seen states claiming conducting cyber operation during ongoing armed conflicts, but no state has for now qualified the cyber armed conflict, an armed conflict only based on cyber operation. So again, we see how these two bodies of rules, jus ad bellum and jus in bello, are applicable, they are important, but they are not yet been applied in this context. So the question I wanted to bring here, based on this different analysis, is why it remains an important focus of the discussion, why it's something that we see coming back in the discussion among states and in the position of states, why they don't use it in real life, they don't apply it, or we don't have that many situations. And I am here expressing 3 reasons why we have this focus. The first problem comes from the fact that cyberspace has been challenging the way states or other actors are able to conduct hostilities or are able to conduct hostile acts against other actors. And that has been one of the issues in the sense that traditionally, when a state or another actor is conducting an hostility against a state, it will be a use of force. And we will have penetration into the territory of another state, we'll have deployment of military and all these questions. So when the question of cyber operation occurred, when it happened, that was the first assumption. We will apply the same legal regime, we will have the same approach, which explained also why, and this is the second reason, the first lawyer which were questioned on this point were military lawyers, which created also kind of a disequilibrium in the approach, because they were more used to deal with question of use of force or question of jus ad bellum, or not used for the rest of hostilities. And why is that? It's because yes, cyber operation may amount to use of force, may take place within an armed conflict or create an armed conflict, but they may also equate to other type of act of lower intensity that in the past were not, or which are still the case, but are not dealt by military lawyers, are not dealt by armed force, but are dealt, for example, by Ministry of Foreign Affairs or Treasury. That's, for example, economic coercions. That's, for example, other type of non-military action among states. Same thing about the reaction. Self-defense was dealt by military lawyers, but questions like countermeasure were mainly dealt by Treasury and Ministry of Foreign Affairs. And that's why we had this difficulty when this question arises, is because we had to connect branches of internationals that traditionally were not working side by side in the same way. And that created this disequilibrium in this question on how to connect them and how actually to bridge these different divisions within the legal approach of states. Finally, on the reasons for this problem, which is a direct consequence of the previous comments, is despite the fact that there has been an important body of literature on this question, despite the fact that there has been different capacity building exercise, training exercise, there is still this perception among policymakers that if it's not possible to qualify a cyber operation as a use of force, for example, they will be helpless in the way they can address it. The state will not be able to respond to the cyber operation and to adopt actions to respond to this behavior. And this is particularly visible in state practice. So there are several examples where we saw this temptation to come back to the definition of the use of force and to apply like the question of use of force and then the question of armed attack and self-defense to cases of rather low intensity. And I think the best example there is SolarWinds, and this is one of the last examples we have on this case, and that's why I wanted to bring this one on the table. So very briefly, SolarWinds is a large-scale cyber operation aimed at spying over different governmental and intelligence institutions in the US and in Western countries, allegedly conducted by Russian intelligence agencies. The way they were able to conduct this cyber operation, which is a very specific type of cyber operation, is they identified that the software named Orion produced by the company SolarWinds was rather less secure than other software or than the computer network of the agencies they wanted to penetrate. They notably identified that this software had still an administrator account using the password SolarWinds123. And using this information, using this capacity, they were able to penetrate into this software and through this software into the different users of the software. What is interesting when you analyze this, the case of SolarWinds, is if you try to apply, or if you apply the different categories of international law, it's an espionage operation, which is likely to constitute a violation of sovereignty. Some have argued maybe a violation of the principle of non-intervention. I think it's more discutable. But then when you see the reaction in the US and when you see what has been the first reaction of the policymaker, it has been to say it's a use of force and we need to be able to use self-defense against that. I don't say that's a general perception, but that's something you have seen and we have seen on other cyber operations. And for example, if you read the blog post that was written by the Colonel Evgeny Vidman, who was Deputy Legal Advisor on the White House National Security Council, he wrote a blog post on lawfare, which is titled, "Is the SolarWinds cyber attack, is the SolarWinds cyber attack an act of war? Question mark. It is if the United States say it is." And the last paragraph of this blog post is, "The Biden administration will need to determine how to respond to the SolarWinds cyber attack to establish deterrence and impose costs given the magnitude of the attack. These are policy issues, but they should inform by the legal determination that the SolarWinds cyber attack may well constitute a casus belli under international law." And that's something very interesting you see with this kind of cyber operation, because we have cyber operation of a rather limited sophistication in some ways. They were mainly like smart in finding the way to penetrate into the software, but in terms of consequences, in terms of action, they have access to computer to spy on information. They have not either deleted data, they have not destroyed physically infrastructure. And the reaction, the perception is it could be a use of force, it could be an armed attack, and then the reaction could be self-defense. So that's something very interesting in the way cyber operations are sometimes portrayed and sometimes approached by policymakers. And it's come by this question on to this question on how they can reply and they can respond to this question. What is interesting also, and that will be the last part of the presentation, is the fact that you see this type of condemnation from different states for the same type of cyber operation, but they are also conducting the same type of cyber operation. And with the United States, for example, one of the reactions has been to say, because they are victims of this type of operation, which amounts to rather brave example, they can conduct preemptive operation in reaction under the policy as a defense forward and the persistent engagement. And we can come back on that during the Q&A. So now I'm moving to the current armed conflict in Ukraine and the type of cyber operation we see in this armed conflict and the different questions it raises. So we see an international armed conflict between two states, and which has a cyber component. What has been in some way interesting, I would say, with this armed conflict is the way it has been perceived, and in some ways, the way the cyber component of the conflict has been perceived by commentators. Before the conflict and at the beginning of the conflict, one of the assumptions by several commentators was the fact that we will see high-scale and high-intensity cyber operations during this conflict. And it seems from the different analyses and from the information we have now, so that may change depending on the information we'll have in the future, ultimately, it's not that many high-intensity cyber operations, and we see rather low-intensity cyber operation, a lot of low-intensity cyber operation, but we don't see destructive cyber operation. And that's an important observation about this conflict. We may discuss why, and we may try to identify why. My analysis of the conflict for now, or of this situation in conjunction with other conflict, is actually the fact that it shows how states are now considering cyber tools as a mean and method of warfare they can use in conjunction with other tools, with other means and methods they have. And this is where also we need to approach cyber operation differently. It's important to identify the operation, to analyze them, but it's also important to see them in the context and how they use in coordination with other type of acts to conduct more complex type of operations, which will actually also affect their legality or their lawfulness. And that's an important, I would say, evolution in more recent conflict or more recent type of cyber operation, where we see them being more and more used in conjunction with other type of acts. So what we saw with Ukraine on that, and which is very interesting in terms of practice, is before the conflict, there has been some high intensity and high consequence cyber operation. In 2015 and 2016, there have been cyber operations aiming and successfully causing blackouts in different cities of Ukraine. And the most well-known example remained NotPetya. So NotPetya was a malware that has been spreading in June 2017. It was looking like a ransomware, that is to say, a malware that aimed at encrypting your computer and saying that if you pay me a sum of money, I will get you back to your data. But actually it was a wiper, meaning that it was wiping your computer and never getting you back access to your data. What was interesting with NotPetya in this case is it's a malware that has been spreading through an accountability software used in Ukraine and targeting Ukrainian companies. But it then, when it had infected the computer system, used a VPN connection and intranet connection within the company to spread over the other branches of the same company all over the world. It is believed to be one of the most costly in terms of consequences. At the time of the cyber operation, you had comments from the White House, for example, evaluating it at 10 billion of losses. It had a lot of legal consequences also later, because one of the issues with NotPetya has been the fact that the victims located in other parts of the world, notably in the United States and the UK, have asked their insurance company to cover the loss, and some insurance companies have refused, saying that since the case has been attributed, it was an act of war, and then it was under the war exemption of their insurance policy. Finally, we had a tribunal that ruled out this option in December 2021 and say that no, the insurance has to pay. It's only one case and there are still other pending cases. So we saw this kind of high intensity cyber operation before the conflict. We didn't see them during the conflict. And I think that's a very important evolution, which shows also how this question needs to be articulated. What do we see during the conflict and what is important in terms of legal challenges is first, since we have mainly low intensity cyber operation, and something we have been discussing already today, but it's this question of whether or not they will fall within the definition of an attack under the first additional protocol of the Geneva Convention. And it's where it's interesting when you see the different approaches we see in the literature and that have been expressed. Because you have part of the literature which advocates to say that to be an attack under IHL and then to be obliged to comply with the requirements of the law of non-conflict, the cyber operation will need to be of a certain gravity, which is close to what would be the requirement for use of force, meaning physical destruction, injuries to people or death of people, which is quite a high threshold as we have seen. So if you follow this path, it means that the cyber operation taking place during an armed conflict will not have to be that compliant with the law of armed conflict. You have also another approach, which I would say is the main one today, which is to say, no, we need to have a lower threshold, and actually the objective is to have most of cyber operation covered by the law of armed conflict, because we need to be able to regulate the way they are conducted and they are used by state in this context. So I would think that's one of the first challenge today is where you place this cursor of the definition of what is violence, which is a relevant criteria to define what is an attack under the law of armed conflict. But for me, the most important challenge that we see with this conflict, and we have seen with other conflicts before, is a question of the geographical scope of the armed conflict. And the fact that, yes, part of the hostilities will take place on the territory of the two belligerents, but also part of the cyber operation emanates from outside of their territory. And that's something important. Cyber is not specific on that. We have seen already ways where other states were used by other actors or were also contributing to a conflict by different means. The difference with cyber is the possibility to be particularly remote from the conflict area, and also the intensity of the actions that may be conducted. So it's where it changes a bit also the approach we may have about these remote actions. So we may have these actions conducted by individuals located outside of the conflict, but also by other states. Regarding the operation conducted by individuals outside of the conflict, we have already examples And we saw the call that has been made by the Ukrainian president for an Ukrainian IT army. We saw also different calls by Anonymous saying that they will be conducting cyber operation on different targets in Russia during the conflict. So that's what we see. And one of the difficulty here is because we are outside of the geographical scope of the conflict, we are outside of the territory of the belligerents. You don't apply the traditional distinction between civilians and combatants. You don't apply IHL. And it's another question. It will be a question of cybercrime. It should be approached as a cybercrime activity conducted from the territory of another state, which will impose for the victim state to ask the cooperation of the territorial state to act against these people. So that's one of the first challenge today. There are also some scholars that claim that we should have a broader approach and we should not limit the application of IHL to the geographical scope of the conflict. And it's where there is today, I would say, a difficulty on that. What is important is if we stick to this idea of the geographic limitation and then it's a cybercrime issue, the victim state cannot take action against these individuals. And that's also an important limitation today, which is sometimes referred to, is the fact that you will have these individuals acting from other states, taking an active part in some way in the hostilities, but yet they feel this problem that it's not possible to take action and, for example, to disable what they are conducting. Then there are other parts of internationals that may be mobilized to either justify an action or to compel the territorial state to act. And we had discussion about due diligence, for example, on that and other body of rules, but that is more difficult. And also one of the difficulties that is usually highlighted is the fact that that will be more difficult to articulate with the speed of cyber operations. Finally, the final question I wanted to discuss here is the fact that some states have been also assuming conducting cyber operation during this conflict, third states, in support of one of the belligerents. And it's where it has been an interesting question that has been, for example, highlighted by the United States Cyber Command General Paul Nakasone, who commented that the United States are currently conducting cyber offensive operations against Russia. And what is interesting in this situation is at the same time, you have this cyber operation and you have declaration by the United States affirming they don't want to be party to the conflict. So that leads to question whether or not this cyber operation, and we don't have information on what type of cyber operation, we just know they are offensive cyber operations, would constitute an element going against the obligation under the law of neutrality, or an element changing the status of the United States regarding this conflict. Whether or not that will lead to co-belligerency in the conflict. And here you see different approach, and that was an element that I wanted to highlight in this discussion, because you have a conflation between what will come from the law of armed conflict and what comes from use at value. And this is, I think, an important element in this discussion. It's a trend we see more and more on this question of cyber operations, is to say, yes, the cyber operation may amount to a breach of our obligation of the United States obligation under the law of neutrality, but this will be excused and that will be justified because either it's conducted as part of a collective self-defense effort at the invitation of Ukraine, or it is justified because, for example, the United Nations General Assembly has adopted a resolution condemning the operation in Ukraine. And you see these claims that have been made on some legal blog posts, for example, or in some discussions. And I think it's important to come back here to the distinction between use ad bellum and use in bello and avoid this kind of conflation, which kind of impair what is the purpose of these two body of rules. And which leads me, I think, to my conclusion. I will ask to conclude. So yeah, I wanted to reflect on the centrality of use ad bellum and use in bello on the different processes and how they are always bring back for example of cyber operation. And I may sound rather skeptical on this body of law, but that's not the purpose of my presentation, of my approach. Is to say there are circumstances, there are cases where these body of laws are useful, they apply, and they are necessary. But if we have this temptation, which is to try to bring into this threshold cyber operation of a lower intensity, or cyber operation that happens outside of these circumstances, if we speak about an armed conflict, there is this risk that we will actually empty these rules, this principle of their purpose, on the risk that at the end, the protective purpose of IHL, for example, or the limitation purpose of jus ad bellum will no longer be applicable to cyber operation. And I think this is one of the difficulties we see in the way this body of norms are today approached and the way they are discussed in this different setting on this cyber operation. So there is two for me, and these are my 2 points, my 2 conclusions. 2 problems here, on which I already mentioned, is this temptation we have to lower the threshold of the use of force in cyberspace and try to fit more and more cyber operation in it. The prohibition of the use of force, on particular an armed attack, on the threshold, on the self-defense, have been created as kind of focal point for our international security system. And if we change that, we have this risk to challenge how this security is functioning. And the other point, which I have already mentioned, is this reflection on the conflation between jus ad bellum and jus in bello, on the risk to say, and as we have seen in previous conflict, and we see it coming back outside of cyber, but we see it coming back in the cyber context, that because one of the belligerents will have a legitimate rationale in the conflict, it could apply differently the law of armed conflict on the different limitation. And we see it in the point I made about the law of neutrality. But we have seen it in the past on the way cyber operation and different elements have been approached. This was something we saw mainly outside of cyber, but we see it now translating this kind of approach with just cause into cyberspace. So that was the 2 points I wanted to highlight, and I will close with that. Thank you very much.
Thank you, Francois. If I can summarize your presentation in 1 sentence, there are no simple answers to this question.
There is no simple answer.
Before I open the floor to questions, so, I'll let you think about that for 5 minutes, and I'm going to use the chat prerogatives to ask the first one. Could you clarify your own position about the definition of attack? So do you think that cyber operations resulting only in loss of functionality are attacks under the definition of additional protocol 1 or not? And if so, it is any disruptive cyber operations, or for instance, only those that target national critical infrastructures? And do you think the same standard should apply to other rules, for instance, the definition of armed conflict? If disruptive cyber operations are included in the calculation, does it apply to both contexts, the definition of attack and the threshold for a conflict? Does it have to be the same, or could it be different depending on which rule we are talking about?
I think it's a very difficult question in the sense that we cannot really give a quantitative answer or really giving like a line. We cannot really define lines, and people are working on that. But I think it's a difficult question. My own understanding of the way I would approach the question, if I start with, let's say, the threshold for an armed conflict, would be to say, for an international armed conflict, I think the threshold can be rather low, because the objective is actually to put in place a protective regime on the operations. What have been one of my arguments on this situation is why states have not raised the question of whether or not there has been an international armed conflict. It's because the purpose is to establish a protective regime for civilians, is to establish rules in the engagement, which have not been necessary in the type of operations that qualify as an armed conflict. So I think it's one of my first limitations. I think the threshold, and they are already distinct, but should be higher, or is higher for a non-international armed conflict. But also that goes with the fact that you need a certain level of coordination organization within the group, which would be difficult to meet for a group only working through cyber means. So coordinated through CyberMin and conducting only cyber operations are more skeptical there. In terms of attack, in terms of definition of attack, I'm rather for low threshold. I don't know really where I would place, but I would say a low threshold in the sense that, again, the objective is to actually find a way to apply the protective region and the limitation to the cyber operations, and it's not to identify a wrongdoing state or wrongdoing actor, which may be wrongdoing then because there is a stricter framework, but it's not to identify a wrongdoing actor. So it's
okay. Questions from audience here or from cyberspace? Kubo Maciak.
Thank you, Michael. Kubo Maciak from the XRC. I'm probably the most underdressed person in this room, for which I apologize, but I'm going to blame you.
And we are all jealous of you because of the weather.
So I have one comment, one question, and one request for advice, if I may. I'll try to do it. The comment is on what you just talked about now, no attack. So I agree with you that I'm also for the low threshold. Of course, the ICRC stands for the position that a lot of functionality already qualifies as an attack. But the comment that I have is to something you said earlier on, which is that on the narrow view, the view taken by certain states that we require physical damage, other cyber operations, those that are below the threshold of attack, do not need to be so compliant with IHL. So I would just add a bit of nuance, and I'm sure that we will agree on this, that even for those states that take this narrow view, there are still rules that will apply to cyber operations below the threshold of attack. So it's things like the constant care obligation, which applies to all military operations. It's things like the obligation to respect and protect medical facilities that applies to any type of conduct. So the obligation to respect objects indispensable to the survival of the civilian population, where the scope of the obligation extends to rendering them useless, which is lower again than the threshold. So that's just a comment kind of to add a little bit to otherwise very elaborate and I think very thoughtful presentation of your argument. My question is about your point about this disequilibrium, and I also agree with you, that in the beginning we had all these military lawyers centered around Mike Schmidt, who worked on the first Tallinn manual, and only then as sort of an afterthought, it looks like, in the Tallinn manual 2.0, the scope was extended and also the debates were extended beyond the military approaches. But when you say that there is now a need to connect branches of law that were not working together before, I wonder if you could elaborate on this, because we sometimes see IHL lawyers, we sometimes have this tendency of looking at IHL as existing in splendid isolation, but it has never existed in splendid isolation. Already Jean-Pierre in the 60s was talking about humane law, which was for him IHL, and human rights law. We have had discussions about the role of international investment law, right, and how that applies in terms of armed conflict. We have now, the Woman Manual is working in outer space questions and looks at the triangular interaction between space law, use of Bellum, and IHL. So I think there is a little bit more to this, and I would be curious to hear, how you see this novelty of cyber operations when it comes to this interaction between different regimes. And then finally, a request for advice, if I may. And this I extend to Marco as well. We have two, okay, good. We are a humanitarian organization. You probably found it for you. But as you know, and you have mentioned, Francois, the multilateral processes that are taking place. So the OWG, the second OWG, is now at a very interesting point because just yesterday, the chair published the zero draft of his report. And so one of the things that the zero draft says is that it's important for states to work towards reaching common understandings on distinct areas of international law. And the ICRC is actually mentioned as a political briefer in the draft report. We will see if states adopt it, and we will see if we get there. But for you, you talked about where are the challenges when it comes to IHL. But I want to flip the question around. Where do you think is the low-hanging fruit for states? Do you have advice for us where we can assist states to reach the common understanding on how international humanitarian law applies to cyber operations? We have now got past the question of whether it applies with the adoption of the GG report last year, but we probably shouldn't set our ambitions too high. And so I would be very curious to hear both of your advice on that. Thank you.
François, you're the speaker. I don't feel if I'm the chair.
Thank you very much, Kubo.
Great, what we've been doing is right relating to Kubo's last question. So I don't know how much you can say about that, but
Yeah, I believe. So thank you very much for your question, for your comments, for your question, and for your request of advice. I completely agree with the comment on the, I haven't been really specific, but yeah, I agree that even if it's below the definition of an attack, there will be regulation or there will be like limitation. On this question of the disequilibrium and your question of connecting, so it was part of the scholarship, but for me it was mainly, when I made this point, mainly part of the way state approach this question and who was a lawyer to be mobilized. And one of the issues is when you ask for lawyers within Ministry of Defense. Yes, they have been working on other regime and they may know, and you may have people, but traditionally they will come back to IHL and to USAT because this is what they usually focus on, because this is the type of operation they have been working on. This is coming from an observation I made when I worked with, well, I was part of the committee that drafts the French position on international in cyberspace. And this is one of the elements when we had the discussion, is we needed to find a way to bridge the different elements. And each lawyer coming from different branches of the state, I would say, will come from a different perspective. That's one of the difficulties today when we talk about countermeasure applied to cyber operation, because cyber operation is an action we want to conduct, and we apply some things that traditionally apply more to financial or legal type of action, and not that much to making something and doing something on infrastructure in another state. So I think it's where I identify this kind of difficulty. And on the question of the open-ended working group on where to move, I tend to be critical in some way on the way we talk about international law in these processes. For one reason is, I think we are at a point where we need to dissociate question on the content of the law, question relating to actual interpretation of the rules and the principle of international law, from question of the politics of international law. That's for me one of the issues we have, and like, as you say, now we have this agreement, which I think is a question of political international to have this agreement on the IHL apply and this discussion. I'm not sure it's the right forum to go further and have a detailed discussion on how the criteria of IHL, how the different rules of IHL apply. And I think it's where it's important. It's more to identify what can be these elements of consensus among states, and then maybe having a more legal discussion in different forums, in different places. For example, with the ICRC, which can organize this kind of discussion, or other type of organization. So I think it's where we reached a bit of a limit. Also because their international is part of a broader discussion with other elements. So I think it's where we need to connect these different elements with the discussion of international law, but more the politics of international law. And maybe if we want to go further on the content, it needs to be discussed in different settings and different approach. And there, for example, for me, one of the most important elements will be exchange of views. So it's what Marco was referring to. We have organized an event where we had this work of exchanges view between different scholars from different countries, and I think that's an important element to have this exchange of view on what maybe the rules, what maybe the principle of international, the way they apply, and that will contribute to this kind of evolution. Same thing with capacity building efforts, which have been conducted by different actors. But yeah, for me, that's where I would place the line in these processes.
Thank you, super.
I'll take a question from our online participants. If we can just be as short as possible in your answers. I'd like to take at least another few. This is a good one. What do you think the legal IHL, UN Charter, or the international law rules, and how can they address non-state actors, corporate cyber actors in this context? Is it something you want to talk about? Or
yeah, I mean, we can talk about, but these rules, the rules of like most of the rules of international have been created to regulate primarily the behavior of states. So that's one of the limitations if we want to regulate the behavior of non-state actor, but still there are set of rules, there are different rules that will regulate the type of behavior non-state actor may conduct, but also that may impose on the state from where this actor acts to take some actions if these actors conduct aggressive operations against other states. So I have mentioned due diligence before, and there are different elements of due diligence that can be relevant. So that would be one of the answers. I would be cautious in, and I think it's sometimes one of the elements when we have this discussion on non-state actor and the international law or non-state actor promoting international is that's not the primary purpose of, for example, the UN Charter to regulate the behavior of non-state actor. And that's something we have also to be cautious about, I would say, if we don't want to impair the content of the law.
Question from the audience here, one sentence questions.
Thank you, Marco, and thank you, François, and for your talk from the University of Essex. Actually, a simple question. You talk about the nitty-gritty of IHL rules and how they apply. Would you consider that data can qualify as an object or property under international humanitarian law? In just to hear your views.
We have the answer.
I know the answer on the back, but he's not sitting there. So I would like to hear whether you think, first of all, whether the answer is yes or no, and secondly, whether it would be helpful to do so.
Good luck with it.
Yeah.
Especially
in your short one, so I agree with Kubo on that, and I agree with, yes, for me, data should be considered as an object, maybe not all data, and there is another discussion. We need to distinguish a different type of data. I will not detail that, but yeah, I think we need to, but I would say generally, yes, we need to turn to that because targeting of data may have grave consequences. And this is also part of what we want to avoid, or we want to limit with IHL. I would say also one of the important elements today on one of the questions is, yes, how to dissociate this different type of data. Is it linked to the authors? Is it linked to really the content? So, sorry, not author, but the owner, to what they are about or where they are stored. And I think there are different elements on that need to be detailed.
Great. Question from Professor Chiara Vitucci, who's following us online. Request for clarification. You said that the US cyber operations against Russia are part of a collective self-defense action. Could they be qualified as countermeasures, third-party countermeasures, and are they permissible?
Okay, thank you very much for the question. So I say it's one of the arguments that has been placed. That it may be part of a collective self-defense effort. It has not been clearly affirmed yet, if I'm not mistaken. On the question of third-party countermeasure, under like the traditional readings or the traditional understanding of the law of state responsibility, there is no third-party countermeasure. So that no third-party countermeasure. Traditionally, it will be third-party countermeasure if there is violation of peremptory norms or certain type of violation. So that here I would be more skeptical on this question, to be honest. But that could be argued.
So you don't think they can be classified as countermeasures?
I think it's more. But again, we need to see also the type of cyber operation, I would say.
Okay. Questions from the audience here?
Thank you for the interesting discussion on counter-USC independent researcher. So my question is about this interaction between user and user network, but about the qualification of cyber operations. So traditionally, or before, we were seeing that we consider cyber operation either as means of warfare and methods of warfare, both of them at least what was mentioned in the two following manuals. Recently, Schmidt is suggesting that cyber operations cannot be qualified as a weapon because their direct consequences is never injury or damage. It's a kind of indirect result of things. So it's better, it is more correct to qualify them as a method of warfare. I don't want to talk about this implication in knowledge, but if you think that this idea may come somehow in the terminal tree, maybe, knowing that he's suggesting, do you think that such a distinction would have an effect in definition of an user form for arm attack in user, knowing that, for example, traditionally, we wouldn't consider acts like economic sanction, which would result a kind of a death or injury as a use of force as such. I want to hear your opinion about it. Thank you.
I'm not sure to really. Can you rephrase just the question?
So if we define
In one
cyber
sentence, please.
operations not as a weapon, but as a network,
Okay.
do you think it will have any consequences in the kind of you set a new definition of use of force or an attack, knowing that it's not a weapon, it's just a technique? In an armed conflict, it's easy because the rules are okay, means and methods are used. But if it's not a weapon, do you think the definition of use of force or an attack can be easily applicable?
I would say we have moved from this question of whether or not it's a weapon and whether or not we need a weapon for the qualification of the different categories. So for me, it's not useful to qualify it as a weapon, and the way you qualify it is not that important, and it's why actually there has been this evolution, for example, for use of force, from maybe a discussion on whether it's a weapon, so it's a vector, whether what is a target, but focusing on the consequences. To say that we need to pass beyond kind of say the fiction of whether or not it's a weapon, and cyber is not the only type of weaponry. We would say that is not a weapon, or that can be questioned as a weapon. So I don't think it's today really a relevant question to focus on whether or not it's a weapon, but there are other elements that are taken into account, mainly like the consequences.
I think we have lost only time for one last question, and I'll take it from my list here. How do you determine? Can you expand on how you determine the minimum intensity of violence for the occurrence of a non-international conflict in cyberspace? How do we know that we have crossed that minimum threshold, and we can say we have a non-international conflict in cyberspace?
So that relates to the question you asked me regarding the definition of attack and regarding the different threshold. I don't have a clear answer to provide, and I'm sorry for that, but we need, I think, a certain level of intensity, and more than intensity, I think it will be a certain duration maybe that will be taken into account to identify that we have something going on, we have a conflict going on, but I may be wrong on that. And I think that's a question to be solved by state practice and to be solved by the way this question will be approached.
We might actually have time for yours.
Thank you. How does this rate be applied, and what would you respond to the argument on reciprocity? It might be more beneficial to lower the threshold in certain circumstances in order to regulate and control the responses to cyber attacks, to regulate under IHL, rather than leaving it to the cybercrime conventions, which, as far as I can see, are optional, easy to find, an exceptional excuse not to comply with.
Which threshold do you want?
So, lowering threshold from conflicts, especially non-international conflicts, in cyber, to cover those circumstances that are not pure cybercrime. In that, the response to any cyber attack will then be covered by IHL as well, not allowing states free rein in responding to what they perceive to be cyber attacks.
I understand the argument, and I think it's an important argument in a lot of questions also relating to attribution, to whether or not we will attribute certain conduct to a state, so where we place a threshold in terms of coordination, inspection, or control. The risk, if you lower it too much, is yes, you will be regulated by IHL in your example, but you have the risk that the state may take military action against groups conducting cyber operation when, if the threshold is higher, it's only police actions, and it's so I would say that's where you have a risk, and I would not be in favor of lowering too much the threshold, because you turn into something different, and you turn in a different way to address the behavior of the non-state actor, of the non-state group conducting the cyber operation. So it's a cursor to find, which is more difficult. But I understand the idea of reciprocity. So that would be my cautious point to say, yeah, we need also to say in the other way what may be the consequences, even if they are within the rules of IHL, there may be also other consequences.
Okay, this is all we have the time for on this occasion. Obviously, the discussion needs to be continued at another time. Thank you all for coming and define Switzerland's tropical weather to get here. Thank you for those who are following us online, and thanks to Francois for giving us so much food for thought.